is wickedness. Crime is greed. Crime destroys families. Crime divides nations. Ladies and gentlemen, you are welcome to the channel. The Minister of Sports, Arts and Recreation, Minister Zizi Kodwa, appeared in court together with a Canadian businessman on a corruption case. According to the state, Minister Zizi Kodwa received a bribe of 1,680,000 rands from the businessman in 2015. He was not the minister at the time. He chose to remain silent about the allegations until the main trial is ventilated in court. That's according to his attorney, Zolama Javu. On the other hand, the businessman denied the allegations made against himself, and he only admits to have given the money to the minister, who was not a government official at the time. He gave the money as a friend to him. The minister was a spokesman for ANC at the time. So the allegations against the businessman was that he bribed the minister to influence the cancellation of the tender at the Department of Home Affairs. Eventually, the tender was cancelled, and it was not because of any influence from the businessman nor the minister. So the tender was never rewarded to anyone. Therefore, the businessman doesn't plead guilty, and that's according to the businessman's lawyer. The bail of 30,000 rands each was granted for both applicants, with conditions, of course, and the trial date is the 23rd of July 2024. Listen to the bail verdict for your indulgence.
Now the court will come and deal with the evidence presented. I would say that the Act, the Section 611B, requires that evidence be presented, and it was done so in this matter, where Exhibit A and Exhibit B were considered as evidence and were presented by the applicants. The state did not lead either oral evidence or present documentary evidence in the form of an affidavit. So there was no evidence tendered by the state. However, they addressed court from sidebar, where they addressed the court on their on how they feel that the applicants should be granted bail, and also on the merits of the case. So the court will say that I'm not going to repeat the personal information that has been given to this court covered by Exhibit A and Exhibit B, but the court will state that yes, it is in the interest of justice. There is no factor that is stated in Section 60 subsection 4 to subsection E that is present in this matter that this court should deny bail. Furthermore, the state is not also opposing this application. And the applicants that are standing before me are figures that are known to the public. That states on its own that they are not flight risk. So on that strength, I will say that the applicants managed to prove on a balance of probabilities that they are candidates for bail, and bail is granted by this court. Now I'll come to the second leg, which is an amount. I'm going to interfere with that one because I see there's disparity coming relating to the amounts. I'm one of the presiding officer. I know that one of the issues that the court should consider is the means of the applicant if you can pay that amount of bail. And this court is of the opinion that the second applicant, if this court can increase the bail to an amount of 30,000, the accused, it will not tantamount accused number 2 of this court of refusing you to be released on bail. Now, the court will make sure that the bail is of the same amount and it's granted in respect of applicant number 1 and number 2, and fixed in an amount as prayed for by applicant number 1 in the amount of 30,000, as well as in respect of applicant number 2, it's fixed an amount of 30,000. Now I'm coming to the condition. The first condition is that first and second applicant, make sure that you attend court on every date, time and venue that this matter is postponed to until it's finalized. Remain in attendance until your name is called. If you fail to do so, warrant of arrest will be authorized immediately against you. The bail will be cancelled. Bail money will be forfeited to the state. Secondly, failure to attend court, it is a criminal offense on its own. So if convicted for that, it will be a term of imprisonment or a fine as a sentence. The second aspect I'm going to request is that it pertains to the passports. I agree that the passports which I have been handed to the investigating officer, probably I'm talking about the personal passport, I don't have any issue regarding the one of the state pertaining to applicant number 2, because that one falls away the moment you lose the position. So on the personal passports, will be kept with the IO, self-analyzation of this matter, all the personal passports that you have, applicant 1 and 2. If there is a movement that is warranted outside the country, the IO should be informed of that movement so that the IO can know about your movement. I know I heard Mr. Makakabe saying that I don't want to be involved. You know, this thing of having a sole decision to one person, sometimes it's not good. But the NPA should be informed that the applicant intends to move, and then they are notified of the movement. The last aspect, it pertains to the witnesses. That's the last condition. Now, the applicants should not have contact with the state witnesses. I'm going to request Mr. Mkakabe to provide the list of the witnesses by end of today so that they know who the witnesses are involved, directly or indirectly. So there should be no contact with the state witnesses. Those are my conditions for this bail.
As please the court. As court, please, Your Worship.
Yes.
Worship, my colleague and I have approached the custodian of the Central Diary with a remand date. The agreed upon date with leave of this Honourable Court is the 23rd of July, 23rd July. It is back to court number 10, Your Worship.
23rd of July, court 10.
Correct, Your Worship. And the reason for the remand, in the light of the fact that copies of the docket will be provided to the defence after this remand, it is for consultation and instructions, Your Worship. And I suppose both my colleague will then confirm and address the court in respect to the date, Your Worship. As please the court.
Thank you, sir. Mr. Smartsmith?
Your Worship, we've agreed to that date in advance and we will collect the copies of the docket now, and hopefully on that day, if all the pre-trial issues have been finalized, we'll be able to postpone for trial, Your Worship.
Thank you.
Your Worship, I confirm the suitability of the date. I also confirm that my learned friend on behalf of the state has indicated that the investigating officer is in a state of readiness to give us hard copies of the docket today. And on that basis, between now and the next date, we should engage with regards to all pre-hearing matters so that we don't overburden this court unnecessarily. So if the docket is made available, it's all systems.
Thank you.
As a court pleases.
Okay.